stakeholders, and you are heartily welcome on this a bit cool Friday in the Free State. I don't know with other areas of the country. As we prepare for the spring, we still need to work and ensure that what we're elected for gets done right on time. On my list of the agenda, in the main, we are going to be dealing with what we're elected for. Deliberations on the civil aviation. We'll have a proposed list of amendments by Mr. Jenkins, and we will then talk to them on my list as much as we can. I thought we will deliberate as Mr. Jenkins moves with the proposal, so that where we agree, where we need to add, we add. That will be the move. And then after that will be the issue of 2 sets of minutes. That is the minutes of the 21st and the minutes of the 25th of August. Let me also hasten to say next week, Friday, we will be dealing with the panel van report that emanates from the report of the public protector. There is a report that was sent to members that has questions, possible questions to be asked to the department on this matter. I request members to go through that report by Advocate Nell and add if there are any further questions except the proposed list of questions on that report. Otherwise, I think let's allow Mr. Jenkins to take us through. Over to you, sir.
Thank you, sir. I hope I am audible. Good afternoon, honorable members, honorable chairperson, colleagues, guests. We have a list. I must actually just credit the state law advisor. He drafted most of it earlier in the year before lockdown. Committee has in the meantime made a few proposals which I will refer to. And I'll just take the committee through it, and Chair, as you directed, after each one I will stop and wait for you to tell me to proceed unless members want to continue with debate around that point. Chair, I hope that members have a copy of the A-list. I don't know if it can go onto the screen or members want to see it. It's not very long, so if it can't, it can't, but it's, I don't know if Valerie can put it up on the screen for members to see. But Chair, with your permission, I'll continue so long. There's clause 1 of the bill. There's an amendment to the...
Let's allow Valerie to try and put it on the screen.
Fine, I'll wait for that.
Chair, it is a Word document, so it might be reading very small on the screen. But also, just so that you know, Mr. Hunsinger and Mr. Sabisi joined the meeting, and I think Mr. Mabena is also going to join the meeting now, so it will correct.
Good. Okay, Hunsinger has joined the meeting. Who else?
Mr. Sabisi from the NFP, and I see that Mr. Mabena, he accepted the meeting, so he might be joining in the next few minutes as well. But for now, the meeting is correcting.
Thank you very much. Can we put, or are you saying it will be too small?
Yes, Chair, it will be too small, so it's best if Mr. Jenkins go line by line for the discussions.
Okay, let's do that.
Okay, that's fine. So Chair, obviously page 1 is just the title page, so we start with page 2 of the document.
Yes.
Clause 1. In clause 1, we have a change of definition of air service, and that's consequential because there's other legislation that's being amended as the department indicated at the time. So there's a new definition for air service. The second amendment to clause 1 is just to put that article "the" after the to insert civil aviation, which is also just consequential to the new board being established, Chair. So as far as I know. So that's the amendments to clause 1, Chair. I don't know if I should just stop there. Clause 8 is the one that's going to keep us up because that's the major part of the bill. But Chair, I can just pause there for any questions.
I think members will indicate if they have any question,
Okay.
and will be patient to go back. Do we have a question? Yes, sir.
Chair, I was trying to check because I was checking the definition between the air services and the civic aviation. What is the difference if they want to insert the civic aviation? What is the difference? What will make the difference in this act?
Okay. Any other question on this one? Nothing. Yes, Mr. Jenkins.
Well, Chair, I'm just referring to what the department said at the time in their PowerPoint presentation. They said that the definition of air service makes reference to Air Service Licensing Act. Now, the Air Service Licensing Act is being replaced by the Air Services Act when it's promulgated. So that's why we have that definition, just to go from Air Services Licensing Act to the Air Services Act.
Okay.
So that's my understanding of that change, Chair. I hope I answered the member's question.
Okay. The member will come back if he has something to say. Otherwise, let's go.
Yeah,
Let's go.
clause 8. Clause 8 is the next one. Now there is just to clarify that the appointment of the board members are by the minister. So we just put in after appointed by the minister, which is an issue for clarity. And Chair, after that, I'm reading now the second point. The second point on the clause 8 is on page 20 of the bill, line 41. Chair, I want to draw the attention of the committee to that change. That has not served before the committee. That specific provision, Chair, deals with when an investigation is instituted. And as the bill stands at the moment, there is an and between the two conditions that must be met for an investigation to be instituted. The department emailed me last night and said it should be an or, not an and. The effect being that either one of the two conditions can be present for an investigation to commence. Now, because I understood that the committee is quite in favor of this kind of oversight and control over the, especially when it comes to investigations, I put it in the meantime, just still in tracking, but I just want to draw the attention of the committee to it. The department said, and perhaps if they are present, they can answer for themselves, but the department indicated to me and the state law advisor as well that, first of all, that it's very difficult for both those conditions to be present. So it will be very difficult to actually give effect to that provision if we don't change and to or. And obviously the state law advisor has also indicated there's no legal problem with it, and I can confirm that it's something that needs to be done correctly. And I think it's a committee must consider it, but I think they should consider it favorably, Chair, if I say so. Chair, just the last point on clause 8 is a spelling mistake that we've corrected from drone to drone. And I'll just pause there. I can hear there's somebody wanting to ask questions.
Okay. Honorable McDonald.
Chair, I propose that the amendment with the or instead of the and will make the legislation a better legislation, especially regarding the way that the committee felt in the aspect of the way that the investigation can be opened. And I think the wording "or" will be much better. And I propose that we leave it as "or" and then continue, Chair.
My understanding
Chair,
was that the proposal was "and." Now the department has came back last night and inserted "and or." Am I correct?
They're setting in "or." They wanted to put, so either one of the two conditions can be present for the investigation to commence. So that's what they want to change, the "and" to "or."
Or. Okay. Honorable MacDonald, are you clear?
Yes, that's what I was proposing, Chair, that the "or" be replaces the "and," so that it will make it easier for an investigation to be started, because both of privileges can be there or not. So then it's fine.
Baba Oketa Mabala.
Chairperson, actually, I'm trying to be differ. I'm not difficult. But you see, if you leave "and," actually, it is very inclusive, because when you say "or," you see sometimes in law, when you say "or," it's something that is not inclusive. I'm trying to check "and" and "or," because "and" is "and" plus. It means there's something that can be added on the act or on the bill.
Yeah. Let's get a proper explanation on that, Mr. Jenkins.
Chairperson, we are dealing with, it's on page 20 of the bill, which will be a new section 46. It's clause 8 of the bill, but it will be a new section 46. The provision deals with the reopening of aircraft accident or incident investigation. And it reads that the minister may, upon request, decide to reopen an investigation of an aircraft accident or incident. And then it gives the two conditions that must be met. At the moment, both must be met. The first condition is there's new or significant evidence that was not considered before that has come to light. I'm paraphrasing. And then the second condition is that the Air Safety Investigation Board's findings were set aside. So as it is at the moment, there must be new evidence and the findings must be set aside for the minister to reopen the investigation. And now the department is saying no, either one can be present. So either we've seen new evidence, therefore we want to reopen the investigation, and that's why I say it makes sense. Alternatively, if the finding of the investigation was set aside because maybe it was an irrational finding that the Aviation Safety Investigation Board has made, then the minister can reopen the investigation. Chair, if I may play devil's advocate for just 1 minute, if we leave it at "and," it means that a court can set aside the findings of the Aviation Safety Investigation Board, and we can still not reopen the investigation. There must be new evidence that's present. Alternatively, one can say there's new evidence that wasn't considered. The minister wants to reopen, but he has to wait until somebody goes to court and set aside the aviation safety's findings, the board's findings. So, Chair, the department says either one must be present for the minister to have the authority, the discretion to reopen that investigation, and that's why I said "or" makes sense to have "or." I hear the member inclusive. I hear what the is there, but maybe with this explanation it'll be a bit clearer what the intention is of this proposal, Chair. But it's really for the department actually to motivate it. I think it's a good change. I think the legislation will be more effective. Thank you, Chair.
Yeah, I also think what the member was raising is to try and make it easy for members of the public to reopen. So "or" means either of the two. If either of the two is present, then we can deal with this matter. I think I want to go, unless there is somebody from the members who are present who wants to say something on this matter before I summarize. Anybody? Okay,
Good.
I think let's take all.
Take it. Thank you, Chair.
Yeah.
Chair, the next clause of amendments is clause 13 of the bill. And what we're dealing with in clause 13 is the issue of the insolvency. So what are we doing there is trying to indicate that the charges, fees, and levies contemplated. No, I'm sorry, Chair. I'm just on the wrong place. I'm just looking.
Clause 13 to
Yeah,
omit
clause.
paragraph D and to substitute the following paragraph
Yes,
by
Chair.
the following subsections. Do you see it?
And yeah, thanks, Chair. That clause, so all it does, it brings into play regulation or making of I'm just looking for the bill, Chair. I just want to see exactly what it does, but it deals with the issue of the insolvency that we looked at, which as far as I know, the committee resolved last time that we should include it and we should still consult around it, but we still need the permission of the House. So, Chair, just indulge me, please. I'm just 917, page 28. Chair, as I said, this is first of all, the charges and fees, there's certain powers that will be, and if we bring in the issue of insolvency, we need this. This is a consequential amendment that they want to then effect, Chair. So I'm just looking at the bill and see what exactly the purpose or why it is that committee has already agreed to this, but there's just an addition to what is in the bill. The bill deals with certain powers that's there, and now we want to add sub 4 and 5. That also then deals with what we do in the case when we need those additional powers, Chair. So what we're saying there, Chair, is and is something that maybe the committee needs to consider further when we make these rules. What I'm saying, I'm not there, Chair. I'm on the other side. I'm with Parliament. When the board makes these rules, they must publish it in the Gazette at least 4 months prior to coming into operation. And then, Chair, sub 5 deals with the insolvency matter, which I was trying to find. When someone is liquidated, placed under business rescue, the civil agent is entitled as a preferential creditor to recover such monies. And that power we're giving there to the Civil Aviation Authority to recover the monies as a preferential creditor is what we've spoken about last time. And there's further amendments in the A list on that, Chair. So the two things that we're doing in clause 13, one is we're putting that the publication of the rules or the regulations in the Gazette 4 months prior to coming into operation. And then also to deal with the issue of the insolvency of the licensed entities that collects money on behalf of the authority, Chair.
Okay. Anything from members? Are we okay?
Yes, Chair, we're okay.
Okay. I think while still on this one, if there's any amendment that is not within the Civil Aviation Bill, like this one, which was not within, I think it will be much wiser for us to include it right now before we take this one back to Parliament. Because then if we continue to insert new amendments, it means we are actually not making it possible for us to complete this bill within the shortest time that we can do. So if there's any other amendment that is not within the bill and we want to propose, I think we better do that today if we are prepared. Otherwise, continue, sir. We are in agreement.
Okay, I'm glad. Chair, there's now two amendments, that's spelling errors. On clause 28, as I said, aerodrone must become aerodrome. And clause 51, the word action must become addition. So those are just corrections to the act as it is, to the bill. So that we will change, Chair. I don't think there's much to say further on that. And if I may, with your permission, go to clause 60.
Yeah. Go to clause 60.
Okay, so clause 60. Clause 60 just deals, I think they're just trying to make it clear that legal action must be taken for any failure by any person to transmit to the Civil Aviation Authority any money, fees, charges, or levies collected on behalf. So that is just to give that mandate or the peremptory function or responsibility on the authority to say you have to collect that money, you must institute that legal action.
Yep. Any take, honorable members? I can see Honorable Penes on the screen. Welcome. Sonishwa. Are we happy?
Chair,
Yes,
Chair,
yes, sir.
I'm checking that on clause 60. When they say legal action that must be taken for any failure by any person, I'm trying to check it must or may be taken.
Mr. Jenkins?
No, Chair, I think the committee wants to put must there. It's not to give the discretion. You must take legal action. Now, Chair, the legal action, I'm not sure if it's defined, but I think it means at least going to the state attorney. I don't know if they use the state attorneys and to say you have to collect that money. There will be moments or there will be incidents where the state attorney will advise that certain monies, if it's not sufficient to cover even legal costs, to write it off instead of covering it. But that will be the balance that one has to try and strike between must and may. But I think that what we're trying to intend there is to say it must be. You can't just write it off on your own.
I think it goes with the spirit of clause 30.
Yes.
Yeah. Otherwise, if we say may, it will be fruitless for us to initiate clause 13. I hope the honourable member understands that the intention is it must, and with those with that balance, of course, if it's not sufficient. Babu Stole, continue, sir.
I understand it, Chair, but I remember when we was in Parliament, when Mr. Mukheng says sometimes must can change to be made. That's why I'm trying to balance that one, because sometimes we have to be guided by what actually happened.
Yeah. I'm saying that the intention here is to allow the Civil Aviation Authority to collect as much as they can in terms of what is owed to them. Am I correct, Mr. Jenkins?
Yes, no, you are correct, Chair.
Yeah, so if that be the case, this piece of legislation must be able to help the Civil Aviation Authority then to realize the intention of this inclusion of clause 30. So must in this case is proper. I do agree.
Chairperson, I must just add that what we are dealing with, we're just changing the wording of the provision as it is in the Act at the moment.
Yeah.
The department wanted to change it in the bill, and I think they've looked at it again and they've tried to make it read better. But it has to do with that you have to take action. It's regulations that the minister can make to indicate what must happen if you don't take action when money is due to you. So, I think the bill speaks of criminal sanctions, but it's very rare that we get an empowering provision that says to the minister, you may make regulations and it has to do with criminal sanctions. We leave that usually for the plenary power of Parliament to create criminal offences. So I think that's why it's been changed to say the minister can now make regulations where what happens, what's the consequences when someone must take action and you don't take action. I think that's the meaning of that provision, Chair. And as I say, it makes sense in the sense that it's an enforcement mechanism, as you say. It's trying to tighten up the governance and the revenue collection.
Okay.
So, Chair, just to clarify that, Chair, from there it's just the schedule of laws being changed, consequential changes. And I think what I want to highlight there, Chair, is the first one in the schedule. That's the Insolvency Act. We've spoken about that. And I've spoken about that last time. So that's just trying to bring in the South African Civil Aviation Authority as a preferential creditor when it comes to a business rescue or an administration or insolvency. And Chair, from there, the way I understand the other amendments, most of them will be consequential because of definition changes and name changes in this act. We have a lot of consequential amendments then in terms of these other acts that brings in the international agreements into operation. So, Chair, that's the A list. And Chair, if you can just indulge me with, I don't know if there's questions on that, but just maybe let me pause there, and if you can just put me back on. If there are no questions on this, there's just two or three issues which the committee discussed, which is not in the A list, and I just want to mention them for the committee to be aware of it.
Honorable members of the committee, there it is. Any other thing?
Aye, Chair.
Who's that? Oh, Honorable Mandisa.
Yes, my friend. I'm trying to check there on G under extent of amendment, the G1, when it says any money, fees, charges, or revenues which the insolvent has collected on behalf of the South African Aviation Authority in terms of Civil Aviation Act. I'm trying to check that the capacity of the aviation, if they says collected on behalf, that on behalf, if they can explain that one.
Okay. Thank you, Mondisa. Yeah, yes, Mr. Jenkins.
Chairperson, that amendment, when one look at Section 99 of the Insolvency Act, because what we're doing with the schedule is we're now saying, because of this amendment bill, certain other legislation must be amended. Now, we've put in this bill that the Civil Aviation Authority is a preferential creditor. In other words, they get the money before all the other concurrent creditors get money in the case of an administration or a business rescue or insolvency. So what G does is simply to add to the list. In the Insolvency Act, there's a list of the preferential creditors.
Okay.
Of course, you'll get a bondholder. You will get the South African Revenue Service will be there. If I remember correctly, the Unemployment Insurance Fund is there. So any monies that's due to the Unemployment Insurance Fund from someone that has gone insolvent or a company, that money, before the concurrent creditors get it, you first pay SARS, you first pay the unemployment insurance. What we're trying to do with G is to say also the money that we collected on behalf, because remember what the Civil Aviation Authority, they license certain service providers to participate in the aviation industry, and for that license they must collect monies on behalf of the Civil Aviation Authority and paid over to the authority, who's basically self-funded through that. But as the department indicated and the Civil authority indicated that when there is insolvencies, they do not get their money, and they have a cash flow problem at the moment because of that. So all that provision is doing is to say, you were supposed to collect money on behalf, now you've gone insolvent. Perhaps you've already collected that money and it's in your account. So first that money must be paid over before you're going to pay the creditors, the jet fuel people standing in line, or people who have serviced your aircraft or provided cleaning services for you or whatever. You'll have to pay the Civil Aviation Authority the money that you've collected for them first. So it is very specific. So it speaks of the money that you've collected on behalf of. So if you haven't collected that money, there might be an issue. But if you have collected that money and it's in your account, you've gone insolvent, your assets is smaller than your liabilities, that provision will give the Civil Aviation Authority the standing to say, well, we need to get our money first before the other contractors get their money.
Yeah.
That's what that provision is doing, Chair.
Honorable McDonald.
Honourable Chair, thank you. I was just going to help Honourable Kitamabala with just to explain to him that every time somebody buys an airplane ticket, there's a fee included for the Civil Aviation Authority. So what it means is that provision there is that when the airline does not eventually pay the money to the South African Civil Aviation Authority and goes bankrupt, the Civil Aviation Authority will become a preferred creditor and will thus get the money first after the taxman. Thank you, Chair.
Thank you very much. Any other input on the A list? Okay, you can continue, sir.
Thank you, Chair. There were three issues that the committee highlighted at its last meeting. The first is, if I understand it correctly, that a commission of inquiry, a judicial commission of inquiry, must be appointed automatically if there was a fatality during an aviation accident. Chair, I'm not 100% sure where or how that should be included. What I want to say to the committee, because this is a matter that's still being deliberated, that section 84(2) of the Constitution gives the president the power to appoint commissions of inquiry. So, Chair, is maybe something one must contemplate, because we're taking that almost discretion of the president away to say in certain instances there must be a judicial inquiry, whether the president wants to appoint one or not. And perhaps there should be some input. I don't know if there has been fatalities in accidents where it was not necessary to appoint a judicial inquiry. Because what we are doing, if we put something like that in legislation, we are circumscribing the president's discretion in his constitutional discretion. And maybe we should just think about that. I don't know if it will be even constitutionally problematic to put that in legislation. I need to do a bit of research on that. That's the first issue, Chair. Just wanted to bring it to the attention of the committee. The second issue, Chair, is of course that the staff at the moment. Do I need to pause? I'll pause.
Yeah, please. Maybe let's, if I recall very well, this issue, why it came here was raised actually by Honorable Mang, if I recall, and it was supported by the committee that if there is an accident, we must have a regulation that begins to say the inquiry must kick in automatically because there is that accident. Now, if you still need time to try and give a proper research on this, have that in mind, that despite the fact that you are engaging us, that is the discretionary power of the president. The committee felt at that particular point that if there is an accident, that accident must be investigated. So I'm sure we'll, as a committee, allow you to make further research on that one and come back to the committee so that we take a final decision on this one. You can continue and get the second one.
Thank you, Chair. The second one is I think it's staff being appointed of the authority, and at the moment it's as the bill, new clause, or it's going to be a new section 86 in the Act. Staff will be appointed by the DG, the Director General of the department, and the committee is uncomfortable with that, if I can call it that, and maybe it should be the commissioner that appoints. So, Chair, that would be, if that is accepted, that would be a rather unproblematic, from a drafting point of view, unproblematic. We'll just change Director General to Commissioner, but policy-wise, it might be more problematic. From a drafting point, it's not a problem. Legally, not a problem, but it's a policy matter, so the committee needs to look at that, Chair. That's the second one.
I'm told Honorable Hansinger is in the meeting. This point was raised by him. Let's give him an opportunity first. Whilst doing that, Advocate Masombuk, you are live on my screen, so I can see somebody next to you continuously engages you. Please tell her to be aware that you are both alive on my screen. Thank you very much. Honorable Hansinger.
Well, it's not Hansinger, Chair. I think it's
Hunsinger.
It's not Hansinger, it's Mapela.
No. Mhlonishwa. Wow. No, I was told that Honorable Hunsinger is present in the meeting. I can see you, but this matter was raised by him. Unless you want to say something on his behalf, I'll accept that. But I thought if he's around, let's give him the first bite. We'll come back to you.
Okay, Chair, let him have the first bite.
Thank you very much for understanding that. Honorable Hansinger. Okay. Let's allow you, Mhlonishwa, to have your bite. Seemingly the member is, yeah.
Thank you so much, Chairperson. I think, if I'm not mistaken, this relates to the amendment, or which one is it? Section 1, where the Section 1, subsection A and B, where they say by the definition of Director of Civil Aviation. Okay, what I want to understand is this. The appointment by the Director General, does that mean the Director General of the Department of Transport, or the Director of Civil Aviation? Or in this case, you want an insertion of the commissioner being the one that actually makes the appointments? I think Mr. Frank can assist there.
Okay. Mr. Jenkins.
Then the department must overrule me, please, if I mislead the committee. But the way I understand it is the director of the authority becomes the commissioner now. The commissioner is not appointing the staff of the authority. It will be the DG of the department, the Director General, that appoints. And that was the issue that the committee had. They said, how can the Director General appoint? I think it also has to do with the authority not being a standalone entity as such, and there's arm's length relationship between them and the department, but it's not an independent entity. And I think it has to do with that. So the committee felt that it should be the commissioner, in other words, the director that appoints, and not the Director General, but it's the commissioner. We're going to call him the commissioner. So that was the issue. So it's a bit of a policy issue, which I think the committee must still consider, Chair. I don't know if there
Commissioner.
is someone from the
He
department
can
who
be
can.
appointed by the very person that is going to investigate.
Chair, is Masombo, advocate, can I clarify if allowed?
Yes, let's allow you, Baba Masombuga.
Chairperson, we've got various committees like this one, Aviation Investigating Board in the department under the auspices of Civil Aviation. We've got Air Service Licensing Council. The secretariat of that particular council is the employees within the department. Their function is to make sure that the council members are paid, issue emails as to when are they supposed to attend meeting. They consult with the chairperson. So those employees, other than performing the secretariat function of the Air Service Council, they've got other responsibilities. So it is not necessarily that even in this instance, the Director General is going to appoint new staff. He's going to designate a staff within the aviation branch that will be assisting, because this is going to be an ad hoc committee. They are not full-time. Therefore, that secretariat, if you can appoint it to do that work specifically, they wouldn't have enough work to do. That is why the Director General designates some officials within the aviation branch in the department to be the secretariat. They will keep minutes of the committee. They will make sure that they've got budget to pay for their sittings. They will make sure that everything is in place, the venues are booked for their meetings, and also ensure that they are paid on time. So that is going to be the duty of that secretariat, consisting of already employed employees in the civil aviation branch, taking care of the administrative arrangement or issues of that particular committee. Because the committee will be sitting, or the board will be ad hoc, will be sitting not every day, then when there is no work for the committee, they continue doing their other responsibilities. So it does not mean that there will be new employment or additional employment to the establishment of the Department of Transport to do the secretarial work of the Civil Aviation Investigation Board. Thank you. And also, maybe to clarify that issue of the commission, I think that particular point was relating to judicial inquiry, not commission. Because when I remember very well, the committee said when there is an accident that is investigated, there must be automatic referral of that matter for a judicial inquest to be conducted, not commission. So I think there, if you can review that particular decision, it was not referring to commission, but to judicial inquest. Judicial inquest falls under the auspices of magistrate courts. And already our legislation the Principal Act is already providing that if there is an inquest that is conducted, the Air Service license, the Air Service Board must provide any statements that might be in their possession to assist to enhance the work of the inquiry that is already taking place. Thank you.
Siyabonga, Baba Advocate. Going back to what you have just explained, let me try and ask, why have we used the word appoint instead of designate, as you explain? Because appoint gives us a sense that in any way the commissioner or the DG will have to appoint. And when you appoint, generally speaking, we take it that those will be the new people. Now, if you're saying these are the people who are already in the department, they are going to be designated, why have we used the word appoint? Advocate? Yes, Bob.
Which section is that?
Thank you.
Chairperson, if you look at clause 22 of the bill, it's not using the word appoint, it's using the word designate. It says all administrative work as well as secretarial function in connection with the meetings of the Aviation Safety Investigation Board shall be carried out by employees designated by the Director General for such purpose. We have not used the word appoint. Thank you.
Okay. So in that case, then the designation by Director General becomes appropriate, because that is the staff that is
That's not
under the department that is run by him.
Correct,
Okay.
correct,
Yes.
Chairperson.
Yes.
And Chairperson, not necessarily only in the aviation space do we have this kind of secretariat of designated officials. We've got also under public transport what we call transport appeals tribunals, which is having a secretariat function, because that appeals tribunal is not full time in the department. Officials within the public transport branch are designated to assist that particular transport appeal tribunals with secretarial issues relating to traveling cost of the members, setting up meetings, making sure that there are venues for those particular meetings, all administrative matters. But the salaries of those particular individuals is already guaranteed because they are full-time employees within the Department of Transport. Thank you.
Is that clear to everybody?
Chair,
Yeah, Baba.
I'm trying to follow the explanation by Advocate Masomboga. But when you check the amendment of the section 1A, when it says by the deletion of definition of director and by the inserting after the definition of chairperson of the council of the following definition, commissioner means the commissioner as defined in section 1. I'm worried about it means they are taking the powers from the director to the commissioner according to this report. What is going to happen, because I'm looking on the amendment that have been made by the department. Thank you, Chair.
Can that be explained to Honorable Member, Mr. Jenkins? Yes.
Chair, I think what we need to understand here is that it's the director that is being changed to commissioner. So all the powers of the director becomes now the powers of the commissioner. The reason the department is proposing that is because of the name director and the salary level or the level of director within public service. And the person here is not really playing the role of a director, but more of a director general, to be honest, because it's the head of the administration of the authority. So changing the name to commissioner, it's the same kind of language that's being used with other entities like SARS, where we also speak of a commissioner as the head of the administration, and I think that's the reason there. But Chair, what we were dealing with is the power of the Director General, and I want to agree with the advocate that power should remain with the Director General, because if you look at that clause 22 in the bill, it speaks of employees that must be designated. So it's people already employed under the responsibility and span of control of the DG. So it does not make sense to say, but the commissioner must designate them, because the commissioner doesn't have any kind of power of control over that employee. So it doesn't make sense. But what the member asked on it's another question, and that is why we bring commissioner in. I try to explain that. If the member, I can try and more, or the department can come in as well, Chair, on your permission. But we're changing that whole area where wherever there was director, it becomes now commissioner, and whatever belonged to the director now belongs to the commissioner. It might even become the same person or remain the same person, but it's just a different name.
It's just a name change.
Yes.
Functions and everything remains the same.
Yes.
But I think let's try and be procedural. You are correct that the matter that is raised by the honorable member is another matter. The matter we are closing is that let's remain with the Director General designating people to go and help the commissioner. I think that's the spirit of this meeting, after some explanation. Am I right, honorable members? Agreed. I can see Honorable McDonald. Oh, yes, the honorable member have been looking for Ndimachelo Onise. Thank you very much. It's agreed, sir. We can move now.
Chair, the last matter that was discussed in the previous meeting is the issue of regulations, and I think the minutes of the committee speaks of Parliament needs to see the regulations after it's been made by the minister, and that's in terms of section 155 of the Act. So what we've done in other legislation going through Parliament, we usually put a clause, or we can put a clause in there that says that the minister must table the regulations in Parliament for 30 days or for a calendar month. Usually it's 30 days prior to the regulations coming into operation. Now, there can be a consequence to that. I don't know sometimes if regulations are made in emergency. I don't know the area as well as the finance area. In the finance area, sometimes one must make regulations very quickly. So whilst in finance legislation we have, usually, I must emphasize that usually we have a provision that says minister must make regulations. That regulations must be tabled in Parliament for 30 days before they become operational. And then we have a clause in there that will say, but if it's an emergency, the minister can make and bring it into operation and thereafter table them in Parliament. But Chair, that is usually the thing. What one needs to watch out for is to put on Parliament any responsibility to approve those regulations, because sometimes when Parliament is busy, those are the things that fall through the cracks, and we're busy with legislation, oversight, and so forth, and then suddenly we need to approve regulations that really need to assist the specific area of the economy or the market or whatever. So I will not recommend that Parliament approve regulations. The members said last time they want to see the regulations, and that we can put in the bill if the members want that. We'll just see the minister must table the regulations 30 days before they become operational. If that is in order with the committee, and I don't know if the department want to say something, Chair, but that's my suggestion. And that's all, Chair. That's all from me in terms of issues that I wanted to raise. Thank you.
It means this was your last issue.
Yes.
That was the committee's last issue that I can remember. Maybe there are other issues, Chair, but that's in the minutes and what I remember from last time. Yes, Chair.
Okay. Siyabonga Baba. Honorable Advocate Masombuga.
Chairperson, relating to the issue of the regulations, yes, there is precedence that because the main purpose of sending these regulations, or maybe the aim of the honorable members, is to have an input on the regulation making of a process by the minister. So in other legislation, what we have done is we have put a clause in the Act that says during the consultation period by means of a gazette, normally we publish for 30 days. During that particular period, before we publish or simultaneously when we publish, we send a copy to Parliament, to the Secretary of Parliament, so that they can distribute among members so that they must have a look at the proposed amendment or draft regulations. During that 30-day period, they must also make inputs to those regulations so that they can be factored in the final draft that will be approved by the minister. I've got an example of that particular clause, which is sitting in the National Road Traffic Act, which provides as follows. It says, before the minister make any regulation, the minister must cause a draft of the proposed regulations, A, to be referred to Parliament for comment, and B, at the same time, to publish in the Gazette together with a notice calling upon all interested parties to lodge in writing within the period specified in the notice, but not less than 30 days as from the date of publication. So that is the clause that is sitting in the National Road Traffic Act. So what we normally do, once we are ready to consult by means of a gazette, we send a copy of the draft to Parliament so that parliamentarians can have a look at it and make an input within the prescribed period of 30 days, simultaneously consulting the members of the public. Then we'll incorporate the comments and we'll produce a final draft that will be going to the minister for approval. Thank you.
So that means as a committee we can also have a bite, we can have a sitting and consolidate our inputs during that 30 days. I'm just asking for clarity, Advocate Masombo, or that means as individual members of parliament we can make our individual inputs.
Good Chairperson, I wouldn't dictate as to how is the committee going to look into the bill, but the aim is to make sure that members of parliament can make input. So if the committee can manage to convene within 30 days and give the minister those particular comments, then it's appropriate, or whether the committee gives individual comments. Remember, the bill is published out there for any person, whether being a member or non-member, to make your own inputs there. So whether it is individual or collectively, but it must be within the prescribed period in the notice. Thank you.
Well, Honorable Hansinger, I remember this issue was raised by yourself. Let's give you the first bite, and we'll then allow other members after you have said whatever you want to say.
Thank you, Chairperson. Chairperson, I think the input of Advocate Mosambuka was valuable, and that indeed the National Road Traffic Act is a very applicable reference, and it aligns well to the type of legislation that we are dealing with here. So I would suggest that we then describe this process and procedure equally to how it is described in the National Road Traffic Act. And it might be accommodatable within the 30-day notice period after and before all the public participation input is also evaluated. The only concern that I have is that we would not have any insight on the final version. So in other words, our input would be equal to anybody else's input to what was published, so that we wouldn't have any idea of what was recommended by public interest and what of that was accepted in the final version. So it's as if we are diluted to equal to public participation, whereas as public representatives, you know, we represent the general public. So I'm sort of caught between those two extremes. Preferably, I would have wanted the Portfolio Committee or Parliament then to have an impression of the final version after public participation, but before it's approved, so that we could have a final recommendation stage, also having insight as to what was submitted during the public participation process.
Advocate. Yes,
Chairperson, though the process is going to be cumbersome for the parliamentarians or the committee to have a look at the final draft bill. Remember, regulation should be a fast regulation-making process, although it must be valid and be properly consulted. So the wording of the National Road Traffic Act, as it stands currently, Chairperson, it worked out very well, even from a practical point of view, within the department or within ministry. Thank you.
Okay. Honorable members, can we live with that? Thank you very much. We are
Chairperson, if
yes.
you'll allow, Chairperson, even if, you know, we could be part of that 30-day period, so that at least we are aware of changes in regulations. You know, if that would be fine. We would go with that.
Okay, I think that's the feeling, honorable members. That's what we are saying.
Yes, we
Thank you
agree.
Thank you very much. Honorable Ramato is here. Okay, that was all from the proposed amendments. Honorable members, any further proposals in terms of amendments from ourselves? Do we have any other issue to raise on this bill as a deliberation matter? Or are we happy? Okay. Honorable Hansinger.
Thank you, Chairperson. Thank you also to everybody that submitted input and advice. At this stage, Chairperson, I'm comfortable with everything that was recommended and that was accepted and proposed. So I'm happy from our side. Thank you, Chairperson.
Thank you. Is that our view, honorable members? Can we second this? We happy?
I second that.
Okay. Thank you very much. Can we deal with the set of minutes of the 21st, which was a Tuesday of August? I've gone through the minutes myself. The minutes dealt with the revised APP, and then it dealt with minutes. Of course, the revised APP will include the revised areas per program. I've not seen anything untoward, but let me allow members, any correction members that you have seen? No corrections?
Move for adoption, Chair.
Honorable McDonald moves for adoption. Who's seconding?
I am seconding.
You are seconding. Thank you, Honorable Ramatwa. The minutes of the 25th of August, the 21st was Friday, the 25th was Tuesday. We deliberated on the Civil Aviation Bill. We also considered an oversight report and the minutes. I've equally gone through the minutes. Any corrections? From my side, I've not seen anything to be corrected. Can we move for the adoption?
Chair, I'm moving for the adoption of the minutes.
Honorable Stoller moves for the adoption of the minutes. Any seconder?
Seconded, Chair.
Seconded by Honorable Hansinger. Just a reminder, honorable members, or if we have anything to say, any question, further question to ask to the department concerning the panel van report of the public protector, next week Friday we'll be dealing with that. So it will be nice that we are not found wanting at that point. If there's anything that you want to raise, members are allowed to raise. Let's say consolidate everything we want to raise as possible further questions. We'll close that opportunity on Tuesday. Otherwise, honorable members and everybody in this meeting, we have come to a logical conclusion of this Friday's meeting.
Chair,
Yes.
Chairperson, before you can conclude, can I just remind the members of one matter regarding the Civil Aviation Bill process and the way forward?
Yes, you are allowed.
Chair, yes, Chair, you may recall in the minutes of 25th August, Tuesday, the matter was raised by Advocate Jenkins about the need for the committee to get permission from the House on the issue that on the SACAR submission and that proposed amendments because it falls outside the scope of the bill. In order for that to happen, Chair, there has to be an interim report from the committee to the National Assembly to get permission. Then that proposed amendment has to be re-advertised for comment from the public because obviously there needs to be consultation on that. So Chair, with the committee's permission, is it possible then to put that agenda item on Tuesday's agenda for the committee to consider the draft interim report that will go to the House? Chair, it's possible that the House will only consider the report after the budget review, but then at least the report will be adopted by the committee then for consideration by the House. And there is already a draft report, Chair.
Yes, Valerie. I think that is in order. Earlier on, I said if there is any new amendment, honorable members who have just joined us, it will be wise for us to also make that new amendment to be part of the report. Otherwise, we'll be delaying the completion of this piece of legislation. Otherwise, I think we are agreeing with what Valerie is saying. Thank you very much. I know it's Friday, month end, and I want to thank all the honorable members who committed themselves to this meeting. To those members who are still not well, Honorable Manu, Honorable Shabangu, and Honorable Noluchungu attending a personal issue. We hope that you are recovered speedily, and whatever issues that is there, Honorable Noluchungu, it must be speedily resolved. Welcome, Honorable Yabo, with a new look, a new way. We embrace, it's not only you can see most of us has changed. And I welcome that change. I can see somebody saying, and yeah, I welcome that change. Otherwise, honorable members, be blessed. Until we meet again, take care of yourself. COVID-19 is still there. Thank you very much.
Thank you, Chairperson. Stay blessed, you too. Thank you.
Long live the Chairperson. Long live.
Wow. 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 Thank you very much, honorable members.
Yeah,
Thank you.
Thank you, Chair.
Yeah.